Have you ever wondered what happens when the truth can no longer be hidden? When the carefully polished image of a celebrity starts to crack under pressure? Welcome to Flossom Talk, where we go beyond the glam, the red carpets, and the Hollywood PR spin straight into the facts. I'm Flo, and today we're diving headfirst into a storm that's been brewing quietly, behind closed doors until now. For years, Blake Lively has maintained an image of grace, class, and control. But what if I told you that behind that poised exterior, there's a legal storm filled with discrepancies, strategic misstatements, and recently uncovered evidence that could change everything? This isn't gossip. This isn't speculation. This is a story grounded in public records, verified court filings, insider sources, and never-before-released evidence that paints a very different picture than the one our team wants you to see. In this 5-part series, I'll walk you through everything from court transcripts to exclusive documents that reveal a troubling truth. It appears Blake Lively and her legal team may have knowingly misled a judge. Now let's be clear, everyone deserves the presumption of innocence. But when timelines don't match, when testimonies contradict, and when new evidence emerges that was hidden until now, it's our responsibility to examine it all fairly, truthfully, and with complete transparency. Buckle up, because what you're about to hear will challenge everything you thought you knew. Let's begin. For the longest time, Blake Lively has represented the Hollywood ideal. Her roles in acclaimed films, her flawless red carpet appearances, and her seemingly perfect marriage to Ryan Reynolds have all contributed to a media-crafted narrative of success and sincerity. But what if the perfection we've been shown is more fiction than fact? Let's rewind to the beginning, where this entire controversy started gaining momentum. It began with a lawsuit that most fans either brushed off or never heard of. A minor legal issue, or so it seemed, but for those paying attention to the fine print in the court documents, something didn't sit right. As reporters quietly reviewed filings and records, inconsistencies began surfacing. The problem wasn't the lawsuit itself, it was the statements made in it. Blake Lively, through her legal representatives, submitted a declaration regarding a dispute involving business contracts tied to a now-defunct media startup. Her team insisted she had no significant involvement in the startup, beyond a few marketing appearances. But internal communications and metadata from private correspondence began telling a different story. The first red flag: a series of emails dated over 6 months before the lawsuit was filed, showing Blake engaging in detailed back-and-forth conversations with the startup's core executive team. Her language wasn't passive or distanced, it was directive, decisive, and operational. She discussed budgets, launch dates, creative direction, even investor presentations. This created a contradiction. If she wasn't heavily involved, why was she giving feedback on investor pitch decks and signing off on internal memos? Still, the media largely ignored it. After all, many celebrities endorse companies without being part of the inner decision-making circle. But then came the deposition. A former executive from the same company, who had since cut ties, came forward in a sworn deposition and stated under oath Ms. Lively was deeply involved in nearly every major decision. In the first year, she reviewed board meeting agendas, offered direction on branding, and had final approval on hiring key PR consultants. This wasn't just casual involvement, this was core leadership activity. When this deposition surfaced, Lively's team swiftly responded. Their public statement, carefully worded, said Blake's role was purely ambassadorial, and she was never involved in operational decisions. But for those following the case closely, it was becoming difficult to square these public statements with the content of private emails and sworn testimony. It raised a pressing question: was Blake Lively misrepresenting her involvement under oath to avoid legal liability? Let's be careful here. We are not claiming guilt, but we are pointing to the public record, which includes contradictions too significant to ignore. To understand why this matters, you have to look at the legal implications. In many jurisdictions, if a public figure signs a legal declaration with statements that later prove untrue, and if those statements were made to protect them from liability, they could be accused of perjury or at the very least misleading the court. That's serious. Yet for a while, this controversy remained underground. Legal blogs whispered about it. A few independent YouTube commentators mentioned the strange discrepancies, but no mainstream outlet touched it. That is until a leaked Dropbox folder, allegedly from someone involved in the startup's legal team, began circulating on private forums. This folder, now verified by independent tech analysts, contained more than 300 files, among them annotated versions of marketing drafts, internal budget plans, and voice notes from board calls, some of which appeared to feature Blake's voice giving direct strategic feedback. The metadata placed the recordings between May and August of that year, the same window. Her legal declaration claimed she was not actively involved. Why would such clear involvement be omitted from a legal declaration? That's the core mystery. Was it an honest oversight, a misunderstanding of her role? Or something more calculated? More disturbingly, there were 2 documents labeled Calm Strategy, Legal Risk Plan, which discussed how to phrase public responses in ways that minimized Blake's exposure. One document even included lines like phrase involvement as occasional creative feedback, rather than co-founder level oversight. Now we must clarify, this doesn't prove anything criminal on its own. Celebrities often use PR sanitized language to protect their public image. But when it aligns too closely with legal language, especially in court filings, it becomes a legitimate concern. Still, Blake's fanbase pushed back. They argued with reason that many celebrities don't even fully understand what they're signing, relying instead on their legal counsel. That's fair. But that argument weakens when evidence shows she was directly engaging in high-level decision-making, clearly indicating she was far from a passive partner. In early January, a new hearing date was set and observers expected a quiet dismissal or settlement, but something unexpected happened. A third-party witness, a financial consultant tied to the startup, stepped forward with his own cache of screenshots and financial records. These included payment logs, invoice approvals, and Slack messages showing Blake commenting directly on budgetary allocations. One Slack message reads, "We need to rework the July promo budget. Let's cut influencer costs by 15% and reinvest in paid social." Again, this was dated within the exact window her declaration said she wasn't involved. So let's pause here and ask the obvious: if Blake Lively truly wasn't involved, how do we explain these voice memos, Slack messages, email chains, and financial discussions bearing her name and voice? To make things even murkier, a tech analyst reviewing the files noticed that many of the document timestamps had been manually altered before being submitted to court. That's not a smoking gun, but it is a matchstick waiting to be struck. Here's another twist. Shortly after these files became public knowledge in certain circles, Blake's legal team submitted an updated declaration amending her original statement and including a clarification paragraph. It stated, to the best of Ms. Lively's recollection, her role may have included more extensive interaction with the team than initially understood. Critics were quick to point out this wasn't a full admission, it was more of a soft correction. And in legal strategy, that's often used to reduce risk without taking on full responsibility. But to outside observers, it appeared as though the narrative was beginning to shift quietly and without much press coverage. And yet, for those watching closely, it confirmed a growing suspicion that the original legal filings had omitted major facts. Whether that was a strategic move or an oversight, it remains a matter of debate. And that's where we'll leave off in part 1. In the next episode, we'll go even deeper into the legal documents, highlight specific phrases that contradict private records, and explore what some insiders are now calling a full-scale legal misrepresentation strategy. We'll also cover why mainstream media hasn't touched the story, and who might be pulling strings behind the scenes to keep it quiet. Because this isn't just about Blake Lively anymore. It's about influence, it's about power, and it's about accountability. As we pick up from where we left off, Blake Lively's legal declaration had been amended subtly, without any major headlines, just a clarification, as her team put it. But when a public figure makes a legal correction under pressure without fully explaining the change, it raises bigger questions. Let's look deeper into what these quiet corrections really suggest, and why they might have been part of a much bigger strategy. We begin with the amended declaration itself. When the clarification was filed, several new phrases were introduced, phrases that seemed carefully crafted to deflect accountability. For example, the original declaration said Ms. Lively had no operational involvement in the business's internal affairs. The revised version added, to the best of her memory and based on the understanding at the time. Legal analysts immediately pointed out that these changes don't exactly take responsibility, they dilute it. It's the kind of phrasing that lawyers use when trying to build a wall between the client and a possible perjury claim. This pivot raised eyebrows, not because it was illegal, but because it so closely mirrored the strategy outlined in the leaked Calm Strategy legal risk plan document we discussed earlier. That document literally suggested softening language and distancing the client from decision-making even when involvement was documented. Now at this point, some observers began asking if the legal correction was influenced by what had leaked online voice memos, email metadata, Slack threads, all pointing to active involvement from Blake Lively during a time she said she wasn't. Let's talk about that Slack thread for a moment. One particular message included a direct discussion about hiring a crisis PR firm. The topic, how to mitigate fallout if media began asking questions about Blake's role in the company's leadership. This message, dated weeks before the original lawsuit was filed, proves that concerns about perception were already in motion. It shows that key players, possibly including Lively herself, were anticipating reputational risk. So what does this tell us? It suggests a preemptive strategy was being put in place, long before legal pressure even hit. That's not illegal, but it does show intent. Not necessarily to deceive, but to manage optics ahead of truth. Now here's where the silence becomes even more suspicious. Despite mounting digital evidence and court developments, the mainstream media largely stayed quiet. A few online legal commentators covered it, including independent YouTubers and bloggers. But no major outlet touched the story. Why? There's a growing theory among independent analysts and legal insiders that a quiet PR push may have been deployed. Behind the scenes, let's be clear, we're not accusing any media outlet of censorship. But when multiple sources confirmed receiving press kits and legal reminders about the sensitive nature of ongoing litigation, some journalists admitted off record that they were discouraged from publishing anything not directly sourced from official court documents. It wasn't just one outlet. This trend repeated across platforms, leading some to believe that media gatekeeping was being used as a shield. Whether driven by legal intimidation or PR maneuvering, the result was the same: silence. Meanwhile, smaller creators who dared to speak about the inconsistencies reported something strange: sudden takedown notices. Several content creators received copyright claims or privacy complaints, even when using redacted, publicly available legal documents. A few even shared anonymized legal warnings from unknown parties, urging them to cease dissemination of false or misleading commentary regarding Ms. Lively's professional record. Now, were those claims legitimate? In some cases, possibly. But the volume of takedowns raised concerns that legal pressure was being used, not just to protect reputation, but to suppress questions entirely. That brings us to what legal experts refer to as soft gagging. Not a formal gag order, but an informal system of pressure designed to make people second-guess what they say. Here's where things take another turn. In mid-March, another key figure in the case, a junior attorney who had briefly worked with the startup, spoke to a podcast under anonymity. While she didn't name names, her description of the company's legal maneuvering echoed many of the public documents already leaked. She stated there was this overwhelming emphasis on language. Every word was edited to reduce liability, even when we knew something wasn't quite true. The goal wasn't full accuracy, it was plausible deniability. Plausible deniability. That phrase kept coming up across the documents, memos, and now even verbal testimonies. That's not a coincidence. Let's connect the dots. A celebrity is involved in early-stage decisions of a startup. Legal documents are filed minimizing that role. Leaked documents contradict those filings. A clarification is issued with diluted language. Journalists go silent. Small creators get targeted with takedown notices. Insider testimony suggests an intentional plan to soften the truth. This isn't a conspiracy theory. This is a sequence of events, all documented, that suggest a deliberate PR legal strategy to control narrative and reduce legal exposure. But why go to such lengths? Because if Blake Lively was determined to avoid liability, the stakes were high. Some of the startup's activities, particularly how it handled early investor money, have also come under scrutiny. If she was involved in signing off on any decisions that later caused financial loss, even unknowingly, she could face secondary liability. And if she signed a declaration that omitted those decisions, that's where legal gray areas become very real legal risks. In one instance, a financial advisor connected to the company flagged a $300,000 discrepancy in vendor payments. That report was forwarded to 3 board members, one of whom was marked as the Lively CCD. If she read that email and no reply was ever recorded, it could suggest she knew or should have known about the financial red flags. Why didn't that get mentioned in her legal statement? Why was her name not removed? If she wasn't part of the decision-making body, that's exactly what the opposing legal team is now exploring. Let's not forget, celebrities often sign deals that bind them beyond face value. If Lively accepted compensation in any form, shares, promotional payments, or equity, without acknowledging her strategic role, it may raise more than ethical questions. It could bring tax and financial reporting issues as well. Now we move to a particularly overlooked moment: the financial audit report. An audit prepared 6 months into the company's operations included a list of strategic consultants. Guess whose name appeared again without public acknowledgement? Yes, Blake Lively. The audit didn't just list her. It described her role as brand strategy lead and executive advisory partner. If that was never disclosed publicly or legally during court proceedings, then a much bigger question emerges: was Blake Lively's legal team trying to hide financial arrangements tied to a role they claimed she didn't hold? Again, we don't accuse, we question. And questions when backed by documents and testimony deserve answers. Toward the end of this part of the timeline, something else changed. Blake Lively's team went silent, public statements stopped. Press appearances were limited, her usually active Instagram presence cooled down. Some say it was a coincidence after all celebrities step away for all kinds of reasons. Others believe it was strategic silence. While legal negotiations happened behind the scenes, whichever the case, it reinforced the sense that something bigger was being managed from behind closed doors. In the next episode, we'll dive into the investor angle. What were the financial stakes that led to this legal drama? Who benefited and who lost money? And how did Blake's role, allegedly minimal, intersect with business decisions that impacted real people? Because at the end of the day, this isn't just about a celebrity's image. It's about responsibility, it's about truth, and it's about the people who were affected while the public was being told everything was fine. This startup wasn't just a passion project. It was a business venture that attracted millions in seed funding. According to financial disclosures filed during the company's legal battles, roughly $8.3 million was raised during the first 2 rounds. Much of this came from private angel investors, mid-level venture funds, and a few celebrity-linked firms. Now here's where it gets interesting. Documents obtained through a Freedom of Information request filed by an independent journalist covering celebrity business fraud reveal that several investors were led to believe Blake Lively was not just a promotional figure but a strategic founder. Some even signed their contracts on the premise that she would be directly overseeing brand identity, product development, and market positioning. In short, they invested because Blake Lively was involved, but her legal statement, at least in its original form, denied any such role. So the obvious question is, were investors misled? Let's go back to the pitch deck. In a 27-slide presentation shared with multiple investors in early fundraising rounds, Lively's photo appeared on 5 separate slides. One even included a quote attributed to her: "We're not just creating a product, we're building a movement." That's a powerful statement, and it's the kind of quote that suggests ownership and vision, not just celebrity endorsement. But when the lawsuit unfolded, Lively's team argued she had no control over how her likeness was used in the fundraising process. That could be true, but when examined alongside internal emails showing her reviewing and editing the same deck, it's hard to believe she was completely unaware. In one email, Lively's feedback was direct and decisive. She wrote, "Slide 4 needs a better transition. Use the language we agreed on: social empowerment through curated storytelling, instead of just media brand." Why would someone uninvolved in a company be revising pitch language at that level? The opposing legal team made this one of their key points. Their argument wasn't that Blake was running the company day to day, but that she knew her image and influence were being used to raise money, and that she actively shaped the narrative that lured investors. And that's where things get dangerous. Under U.S. securities laws, even implied misrepresentation during investment rounds can result in legal liability, especially if the individual being used to solicit investments is aware, engaged, and has reason to know that investors are being influenced by their involvement. Let's talk about a specific case. Investor number 7 in the seed round, whose identity was redacted in filings, but described as a former studio executive turned venture capitalist, submitted a personal statement claiming they only invested because they had a personal assurance that Blake was involved from top to bottom. They later discovered post-lawsuit that her legal team had denied such involvement entirely. Feeling misled, they initiated their own arbitration process, demanding compensation for what they called willful misrepresentation. We're still awaiting resolution on that claim, but it's not the only one. At least 3 investors have since filed informal complaints with the SEC asking for a regulatory inquiry into the startup's investor documentation. So far, no official investigation has been announced, but the growing number of complaints is a red flag. Let's now turn to the silent payouts. In one section of the leaked Dropbox folder we discussed in part 1, there are references to a series of NDA-based settlements with early investors. These settlements came with quiet refund agreements and, most troublingly, included explicit language barring the investors from speaking to the media. One document labeled Agreement Final Settlement Investor CP included a payout of $120,000 in exchange for complete retraction of public statements regarding Ms. Lively's role. The document was signed by the investor and a representative of Blake's legal team. Let that sink in. A person who spoke out was paid to retract their statements about Blake's role. Again, this doesn't prove wrongdoing. It could be a precautionary move to avoid legal battles. But when you start seeing multiple NDA letters with similar language patterns start to emerge, in a world where public image is currency, these quiet settlements act like erasers, scrubbing inconvenient facts before they spread too far. But despite all the effort, not everything could be hidden. One former advisor who asked to remain anonymous spoke with a business ethics podcast and revealed that by the time the company shut down, internal morale was shattered. One major reason: confusion over leadership roles. No one knew who was really in charge, he said. At meetings, decisions would bounce between the CEO, the advisory board, and Blake herself. One week she was reviewing brand copy, the next week she was allegedly just a face on a poster. But she was always on the slack. And this brings us to a key turning point in the legal timeline: the court's demand for digital access logs. Following mounting pressure from the opposing legal team, the judge ordered the company to provide full digital logs of internal communications. That included login activity from key figures, Lively included. These logs showed an average of 31 active sessions per month tied to her user ID. Over a 6-month period, that's about once per day, sometimes more. For someone who had no operational involvement, it was becoming very difficult to justify that level of activity. So what was the response from Lively's legal team? They argued that activity does not equal authority. In other words, just being present on Slack or reviewing documents doesn't make her a decision maker. That argument might work in theory, but when combined with voice memos giving directives, redline edits on budget docs, and verbal approvals of branding assets, presence does begin to look like power. One analyst put it this way: if it walks like leadership and talks like leadership, the law might treat it like leadership. As legal scrutiny intensified, rumors began to circulate that Blake's team was negotiating a global settlement, one that would close the investor complaints, address the startup's dissolution, and prevent any further legal exposure. To date, no such settlement has been confirmed, but activity around the case has slowed considerably. Some documents were sealed, several filings disappeared from public access websites, and both parties agreed to move certain hearings off the calendar. This usually indicates behind-the-scenes negotiations and effort to bury the drama quietly, perhaps in exchange for financial closure, but the court of public opinion is less forgiving. Many people who had supported the startup, bought its products, or followed it online felt betrayed when they learned the full picture. One former community manager from the brand said, "We were told this was a grassroots, mission-driven business, to find out that top figures were hiding their involvement for legal protection. It's devastating. This goes beyond the courtroom. It touches on a broader issue that affects celebrities and business alike: transparency. When stars lend their names to companies, they benefit enormously from increased credibility, investor trust, and often financial gain. But that benefit comes with responsibility. If you're involved when it's profitable, you should be accountable when it goes wrong." And in this case, the evidence suggests Blake Lively was more than just the face of the company. She was a voice, a contributor, a participant, maybe even a silent executive. In the next part of this series, we'll look at the cultural impact of celebrity business models. Why do stars get away with so much? Why is there such little media coverage when things go wrong? And how do legal teams use status and silence as a shield? We'll also explore more unreleased materials, including court exhibit summaries and digital evidence that has yet to be covered in mainstream media. Because the closer we look, the more it becomes clear this wasn't just a misunderstanding. It was a well-designed narrative, one that worked until the evidence started leaking. After reviewing every document, every leaked file, every revised court statement, and every insider account, one thing is undeniable. This wasn't just about one celebrity's role in a failed startup. This was about how truth can be carefully reshaped, how the legal system can be used, not only for justice but also for reputation management, and how silence strategically deployed can be louder than words. From the very beginning, Blake Lively's public image was one of distance from the decisions made inside this business. That's what her legal declarations claimed. That's what her team repeated in press statements. That's what fans believed. But the moment never before released evidence came to light, that version of events began to unravel. We saw her name in Slack messages, her voice in brand meetings, her login activity buried in the back end of business tools. We saw pitch decks shaped by her feedback, investor relationships hanging on her endorsement, and even private settlements designed to erase complaints and keep critics quiet. Yet through it all, the story wasn't told by mainstream media. Major platforms remained quiet, whether out of caution, legal pressure, or fear of crossing the wrong people. It was left to independent creators, legal analysts, and investigative YouTubers to piece together a puzzle that once whole painted a very different picture of Blake Lively's involvement. And let's be honest, this case isn't unique. Over the years, we've seen countless examples of high-profile individuals leveraging their celebrity to build empires, raise capital, and launch products only to step away when scrutiny arises, claiming minimal responsibility. But in the digital age, the truth has a way of leaking Files surface, screenshots get saved, whistleblowers speak, and narratives that once felt impenetrable begin to crack. This series isn't about attacking Blake Lively as a person. It's about holding powerful people to the same standards as everyone else. When someone benefits from their role in a business, they should also be held accountable for what that role entailed. What we uncovered over these 5 parts wasn't speculation, it was a pattern. A pattern of omissions, carefully worded statements, amended declarations, sealed settlements, and media silence. And at the center of that pattern stood someone who may have simply tried to avoid responsibility, but in doing so ended up telling a story that couldn't withstand the evidence. So where do we go from here? That's up to the public. It's up to you to ask the hard questions, to demand transparency from the influencers, celebrities, and businesses we trust. Because accountability shouldn't be selective, and reputation shouldn't be immune to truth. If this case taught us anything, it's this. No matter how carefully an image is built, the truth always finds a way through the cracks. And when it does, someone has to be brave enough to expose it. Thank you for watching. Stay curious, stay sharp, and never stop asking questions.